case. We are holding hearings on various motions scheduled for this morning. Before we get started, the court will note there is an order governing courtroom conduct that's in effect in this case. According to the terms of that order, other than what's been specifically authorized by the court, there's not to be any unauthorized photography or recording of these proceedings. And if you have any personal devices that will go off or make a sound, please make sure those are silenced. If they do go off during the proceedings, I'll instruct the bailiff to take those and hold them until we're concluded with our motions this morning. So scheduled before the court are various motions, including a motion as it relates to a reconsideration of the court's previous order on video and photographic coverage of the trial in this case. That's scheduled to be heard this morning. We've also got the state's motion to amend the indictment, the state's renewed motion to reconsider change of venue. We've got the defendant's motion in limine, requesting a motion in limine to limit the state to consistent arguments. There's also two additional motions filed by the defense relating to a request to strike the death penalty in this case. So we'll take these matters up in the order I just announced them. So let me just inquire first, starting then with the reconsideration of video and photographic coverage. Is the state ready to proceed with that motion?
Yes, Your Honor.
And who will be arguing that?
I'll be arguing that motion.
Very well. And then is the defense ready to proceed on that motion?
Yes, Your Honor.
All right. I'll note also on that motion, the court will permit and has considered briefing that was submitted by interested parties. Wendy Olson representing those interested parties who will be allowed to submit argument for today's hearing. Is Ms. Olson present here?
I am, Your Honor. Thank you.
Thank you. And you'll be presenting argument today in addition, is that correct?
Yes, Your Honor.
All right. The court will permit that as well then on the motion. So we'll start then with procedurally on the motion. The court had entered a order in the what used to be the companion case of 22-21-16-24 State versus Lori Vallow, and that applied to both cases. The court thereafter had concluded that when that trial was complete, the issue of coverage would be reconsidered here, mostly for the reason that there was a mutual request in the Lori Vallow case, which the court considered, and the parties are in a different posture here where the defense has requested that the court permit photography or video of the trial here. Mr. Pryor on behalf of his client, and we're at different proceedings, a different case now, and that other case has been concluded. So based on that, the court mentioned to counsel in a status conference that we would address the issue today, and then I issued an order on October 11th that we would hear argument on the issue today concerning camera coverage of this case continuing, as well as the trial that's scheduled for March of 2024. So at this time, the court would note I have reviewed the briefs. I'll begin with the state's argument on the issue here. After that, I'll hear from the defense, Mr. Pryor, and then finally after that, Ms. Olson, if you'd like to make any argument on behalf of your clients, you can do that. Mr. Wood.
Your Honor, respectfully, I'd actually ask that we reverse that order. This is technically the defendant's motion, and the interested party agrees with the defendant. The state is in a responsive posture. We'd ask to be able to go after them to be able to respond. That being said, if you want me to go first, I can go first. I just think that would be the appropriate manner to proceed in.
All right, and I don't mind switching the order given that. Mr. Pryor, your thoughts?
Well, Judge, my thoughts are simply this, is that unlike the change of venue, which was the prosecuting attorney trying to have a court reconsider a motion without any lawful authority, because in the venue there is no lawful authority for them to hear a motion to reconsider. In this particular case, it was the court's own initiative that said that given the posture that they would do a motion to reconsider, and the court is well within its right to do that. In essence, what it is, Judge, is it's a first-time motion to allow cameras, and as such, I think that it's proper that the state go first and followed by the defense and Ms. Olson.
All right. Quite frankly, I'm not sure that the order matters that much in terms of how persuasive the arguments would be. I would note it was the court that raised the issue sua sponte in its order to review the issue given where we're at. Mr. Wood, I'll hear your argument at this point, and then I will hear the response from the others. I'll allow a rebuttal, however, after they've made their arguments. So if you'd like to present argument now, you can.
Very well, thank you, Your Honor. So the motion before the court is whether or not we allow live broadcasting or cameras into the courtroom. And I want to start out, I understand these are adversarial proceedings. We do not, the state does not see the media in any way as an adversary. We are grateful for the media. We respect the media. There's a reason why the right to a free press is in our Constitution and one of the first things mentioned in the Bill of Rights. We understand they have an important role in preserving government transparency. They have an important role in informing the public. And so we do respect them. This argument is not at all about whether or not the media should be allowed in the courtroom. They should be allowed, and we're glad they're there. In terms of broadcasting the trial, and the state at least is going to address broadcasting the trial and broadcasting any further pretrial hearings. We shouldn't fix what isn't broken. This court made a very good decision. I believe it was in September or October of preceding of last year. And we think the court was correct when it made that decision. We think that that decision led to more professional proceedings and helped in preserving the rights to the parties, the rights of the parties to a fair trial. Again, we're not arguing that the media should not be allowed in the courtroom. In our brief, we talk about that. The right of the public and media is important in the courtroom. This specific issue is addressed in an Idaho Court Administrative Rule 45. This court has sole discretion over this matter. It's not even appealable by any of the parties. So the state has raised these issues several times. We actually raised this in the previous case before a preliminary hearing. Our concern, I'm going to talk quickly about pretrial hearings. Pretrial publicity can impede the ability of the parties to a fair and impartial trial. This cannot be denied, and it rose its head in the last trial. Individuals who had seen specific media programs were automatically cut from the jury. We expect that issue will be raised again. And while the state doesn't necessarily agree with a wholesale cutting those individuals out, we understand the concern of when someone has consumed too much media about a case, that it may make it difficult for them to render a fair and impartial verdict. And so in terms of at least pretrial hearings from here until the trial, the state's biggest concern there, and this might be our biggest concern overall, is if any of those hearings deal with evidence that we will be discussing at trial. We believe that by broadcasting it, it makes it even more easy to consume by the public, by the mass public, and creates further issues when picking a jury. And again, we've already seen it. This isn't a hypothetical. It's happened. There's no reason to believe it won't happen again. Again, we're not saying the media shouldn't be allowed to report. They should. That's important. There is a difference between reporting, though, and the ability to live broadcast. And there's nothing in the law that states that they have to be able to live broadcast. In terms of trial, And I don't want to regurgitate everything that all the issues I raised in my briefing. There's a lot of people who are called to witnesses in this case who want nothing to do with it. They're not there because they want to be. They didn't get dragged into a triple murder, horrible case, a sordid case, because they wanted to be a part of it. And the state is concerned, and we think validly so, about the effect on witnesses of knowing their face is being plastered on TV for millions of people to see. It's already hard enough to get on a witness stand, be placed under oath, and then to be direct examined, to be cross-examined. Trial gets aggressive. And then to have that added pressure of knowing my next door neighbor can watch this. The people I go to church with can watch this. It's not conducive, especially in a case like this, with fair trial for either of the parties. We understand that the defendant has a different position on that. We believe strongly that having live broadcasting this trial only makes it more difficult to get to the truth of the matter. As stated before, we do not believe that visual broadcasting is necessary for a transparent and a public trial. We believe in an open and public trial. Transparency does not require mass publicity. And there's no rule, there's no law that says that it does. And I would note, and I put this in my brief, at the last trial, at Lori's trial, there was a lot of reporting, and it was minute by minute. I called it live tweeting. I don't know if there's a specific other phrase for that, but where multiple reporters in the courtroom or in the auxiliary room were able to live tweet, and that was great. I fully support that, and in as much as we are able to follow it, it appeared to be very accurate and timely. And so the public, the interested public, was able to follow by the minute what was happening in the trial. They didn't need to watch it. They still got that information. And again, as far as the state could tell, it was accurate information. It was a job well done by the individuals reporting on the case. And so not only that, there's a transcript. People can obtain the transcript. There was an audio recording that was provided at the end of each day. And so in terms of a transparent and public trial, we don't have to point cameras in people's faces for the trial to be open, transparent, and public. I would quickly note, the state is aware, many of the victims in this case feel differently than the state. I know there was news articles about that last time. We don't technically represent the victims. We respect them and their desires, and it's appropriate for the court to know they don't necessarily agree with us on this. And so if we keep the status quo, if we keep it where it's at, there's no risk of a non-public trial. There's no risk of a non-transparent trial. The state doesn't see an upside to bringing cameras into the courtroom. It worked well the last time. Again, we shouldn't fix what isn't broken. And I put this in my brief, and if the court decides to change its decision, we respectfully request a few things. We would ask, and this hasn't been an issue lately, and it wasn't an issue at the last trial, but just, I guess, preemptively, we would specifically request that no media microphones be placed at counsel's table, as took place in some of the other pretrial hearings. We believe that violates Idaho Court Administrative Rule 45C, or at least has a very grave ability to violate that rule. We would ask that the court consider alternatives to live visual broadcasting, such as still photography. And should the court allow visual broadcasting, we would ask that the court essentially retain tight control on that, at least while it's being done. As this court is aware, once video is made and public, the court loses any and all control by rule over what happens with it. but we would ask that the camera placement be limited. We think a good model would be Ms. Vallow or Ms. Daybell's sentencing, in which I believe there was a camera on the court and one camera pointing at the parties. There was no zooming in on attorneys, on witnesses, on victims. And so we would ask that if the court does change its decision, that it do so within that framework to maintain the fairness of the trial. Again, we do not believe that live broadcasting is necessary. Thank you.
All right, thank you for the argument, Mr. Wood. Mr. Pryor.
Judge, the primary reason for Mr. Daybell requesting the cameras is to allow his family to view the proceedings. They would like the opportunity to watch on TV and to see how the trial transpires, and those children that aren't going to be witnesses would like to be able to do that. It's extended family as well. That's our primary reason for doing that. I'm concerned about live streaming because that allows, in my opinion, less control. Cameras, in addition, in the courtroom, we lose a little bit of control as well. But I'd be more concerned about a cameraman who's, while this thing has been proceeding, has snapped 1,000 pictures of me and Chad while we're sitting here. That's a bigger concern for me than the actual cameras. We can't control what this cameraman's doing and the pictures he's taken. He's been snipping along, and I'm sure I'll be seeing them with Mr. Eaton's website later today or tomorrow. The court, however, can put some conditions on a live camera. And on a live camera, like Mr. Wood pointed out, and I wholeheartedly, and quite frankly, Mr. Wood, I agree almost with everything you say. He makes a good, valid argument, Judge. However, the overriding concern is that when our founding fathers started the process of deciding that there would be a public trial, we didn't have cameras. We didn't have ability to broadcast this. And the idea behind a public trial was that if you brought allegations against someone and they wanted to answer those allegations, they should be able to do that in a public forum. And the stay of media and the amount of attention, and I do disagree with Mr. Wood. East Idaho has been saturated with media attention on this case, but the reality is this is a national case. It has garnered tremendous attention. And a public trial is just not limited to people coming from Fremont County to sit in the courtroom and watch the proceedings. And having sat through the entire trial of Lori Vallow and watched the entire proceeding, there were issues with the live feed. I'm opposed to the live feed. I just didn't think it worked. It wasn't pragmatic. It wasn't practical. I think that let's use the professionals who know how to do this. I don't like the idea of a camera being pointed in my face for what's going to end up being 8 to 10 weeks. I dislike even more a photographer taking pictures of me while we're sitting here. And I'd much rather have a cameraman with that. And Mr. Wood pointed out some of the restrictions that we could apply. And I agree with what he said. No mics at the tables. I guess if you have to point the camera at Mr. Daybell and I, go ahead, and Mr. Wood and his group as well, and at the witnesses. But part of the reason behind a public trial, Judge, is accountability. And that's a big overriding factor. And when you're talking about due process and people having a fair right to a public trial, accountability is important. And as much as I don't like the idea of being on live TV, national TV, and I don't like the idea of it at all, the reality is it keeps everybody honest. It keeps the system honest. It keeps the witnesses honest. It keeps everybody honest. And and I'll disagree with Mr. Wood in just this regard. The fact that you have a camera on you, the fact that people are watching this in a public, much like when our founding fathers, you had to answer questions in a public forum, that makes the system honest. And that really is what the driving force, Judge, is allow the public to see this in an honest way, be able to see the entire evidence, not what press releases that people are releasing, not what certain news media report. Let's allow the public to see this in a public way and allow what really is should be a public trial. And again, allowing Mr. Daybell's family to review the proceedings. You could imagine, Judge, that if they show up to court, they would be inundated, whether it was here or anybody else, with the media hounding them and the victims as well, and everybody else who's involved in this, allowing them people to watch this in a public setting. There is one caveat. By doing this in a public with live cameras, Judge, that does create a concern for whether or not witnesses are watching the proceedings. And I guess I don't know how the court would address that, and that's something the court does need to look at. That doesn't change my position that I believe it should be a public hearing with cameras, but controlling how witnesses are limited in watching the media, and maybe the prosecutors and I could work out something with all of our witnesses saying, absolutely no opportunities to view this. If the court allows us to be a public trial with cameras, there's going to have to be some sort of an order that advises all of the witnesses that they are not under any circumstances to review the proceedings or view the proceedings. So that is a concern of mine, but I still stick with our original position that we need to have cameras in the courtroom, Judge. Thank you, Your Honor.
All right. Thank you, Mr. Pryor. Morning, Ms. Olson. I'll note now we'll hear argument from Attorney Wendy Olson, who's representing EastIdahoNews.com, the Idaho Statesman, Idaho Press Club, and States Newsroom, doing business as Idaho Capital Sun. Brief's been filed. The court's reviewed that, and if you'd like to present argument in support of your position, you can do so at this time.
Thank you, Your Honor. And thank you for allowing my clients to be heard this morning. As the court noted, the clients are 3 Idaho-based news entities, and then the Idaho Press Club, which is an association of journalists who work on a variety of First Amendment matters to ensure that they can have complete coverage of matters of important interest in the state of Idaho. Your Honor, the entities request the ability to have live audio and visual coverage of the proceedings in this case, consistent with Idaho Court Administrative Rule 45, in a way that will allow the defendant and the state to have their constitutional interests protected, in a way that is designed to respect the privacy concerns of jurors and the sensitivities of witnesses, and to really observe the dignity of the courtroom. And I think, Your Honor, that the media entities that are before you here have done that in other cases, and they would want to work with the court on any restrictions the court thinks is important to maintain the dignity of the courtroom, to ensure that sensitive witnesses, maybe only their audio is heard at the time. They would want to work with the court to ensure that whatever guidelines the court imposes, that they would follow. But they think it's important to have cameras in the courtroom and have live audio-visual coverage of the proceedings for several reasons. Primarily among them, Your Honor, the point that Mr. Pryor touched on is that we are in an age now where visual coverage of just about every aspect of public life is there, where people really have the opportunity to see with their own eyes, not by sitting in a courtroom, but by sitting in their living rooms or sitting in their offices to watch those proceedings. The Kyle Rittenhouse trial had extensive coverage, TV coverage. Certainly the Derek Chauvin case did. That started out of COVID, but the judge after that realized the importance of having cameras in the courtroom. And then more recently, the Alex Murdaugh trial in South Carolina, where the coverage there was basically from the opening of the trial through the sentencings. And I think that the coverage in those cases showed how, with guidelines from the court, it allows the public to observe firsthand what goes on in the courtroom. I know the court indicated that you read our submittals, our pleadings. I would also ask the court to take particular note of Rebecca Boone's declaration, in where she talks about, she's worked with Idaho courts, Idaho journalists, the law school, to try to improve coverage of our court system. We learn a lot in the public about the executive branch and the legislative branch. but less is known about the judicial branch and how it operates. And I think it's important for people to be able to see firsthand what happens in a trial. How is evidence presented? I think it's important to the point that Mr. Wood raised, that it's important for them to see the impact that participating in a trial demands from the people who participate in it. It is no doubt, Your Honor, that the criminal justice system, the system that I participated in for most of my legal career, is very hard on the participants. It demands a lot of people. It demands a lot of the lawyers, of the court, of the jurors, of the witnesses, of the family members. And I think that covering the proceedings live will allow the public to understand that better, because it is still a relatively rare thing for people to have firsthand involvement in any aspect of court proceedings. I think secondly, Your Honor, why it would be important and helpful to the court to have live audio and visual coverage is it would reduce the demand, frankly, for space in the courtroom. It's my understanding that the attendance at this hearing by the public is less than in past hearings, and maybe that's because the court elected to broadcast this live through the YouTube channel that the courts have used. Certainly, that will help the court with security and with other administrative needs and getting the trial done in a way that is most efficient. And so we think for that reason as well, it would be important to have live audio and visual coverage of the proceedings. And finally, Your Honor, with respect to how that is done, again, the media organizations want to make sure that they are working with the court on all of those things. And I know that the proceedings are being done through the court's technology today, but I would invite the court to not do it that way at the trial if the court allows visual proceedings. And that's really for several reasons, Your Honor. First, it is because the journalists who are experienced camera operators, typically who will do the pool reporting, they have more sensitive cameras, better cameras, and more sensitive microphones that could be placed, not at counsel table, but somewhere else if that is the court's direction. In addition, Your Honor, the court would not have to worry about whether or not there are any technical glitches if the cameras are being operated by the pool camera reporter. Of course, neither the parties nor the court nor the jurors nor anybody would want to have interruptions during the proceedings because there was some glitch in the technology. And then I think, Your Honor, again, with having the members of the press who are experts in operating their camera, they would work with the court to ensure that there isn't anything unnecessarily intrusive if they were the ones to operate the equipment, as was done, I think, at Ms. Vallow's sentencing. And so I think for all of those reasons, Your Honor, our clients would like to see the live audio and visual coverage of the proceedings. I well understand, too, both Mr. Pryor's and Mr. Wood's concerns about witnesses watching things that they should not watch before they testify. There's nothing sort of less comfortable as a prosecutor to know your witnesses have received outside information, and then that comes in at cross-examination. And of course, we want to make sure that jurors aren't watching the proceedings. With respect to the jurors, Your Honor, and them reading coverage of the case once they've been set, that's a concern in every trial. The court gives firm instructions about that, and I think as media has evolved, the court's instructions on those issues have had to change over time to include, for example, social media. I know in the federal courts there's a social media instruction that's given all the time now about don't look at social media when you're a member of the jury, and this court can certainly craft instructions that would cover all of the concerns the court would have with respect to the jurors potentially watching anything that comes from the live audio and visual coverage of the trial. Of course, hopefully they wouldn't be watching while the trial was going on. And then, Your Honor, with respect to the witnesses, it really was incumbent upon the parties, and Mr. Pryor alluded to it, to speak to their witnesses and firmly instruct them not to watch and not to be influenced by any other evidence. It's no different than telling them don't talk to other witnesses about their testimony. It's important that their testimony be from their own independent recollection. And those are challenges that are present in every kind of case, and here they're even more so because of the prior trial of Ms. Daybell. And so we would ask the court that, in considering those factors, do the things that the court and the parties typically do, which is to give very firm instructions. Thank you, Your Honor.
All right. I do have a few questions for you, Ms.
Sure.
Wilson. Reading through your brief, you go through some policy arguments about why it's important to have cameras in the courtroom for these proceedings. One of your captions is, "It will help enhance the public's understanding of court proceedings and promote respect for the rule of law." I'll note in my background, I did some federal criminal defense work. I was a CJA attorney for about 15 years, and I believe you were the U.S. Attorney for Idaho during the time I was CJA attorney. In the federal courts, they simply have a Rule 53 that there is no permitting of any photographs, any video at all in any federal proceeding. Is that your understanding of how the federal system works?
It absolutely is, Your Honor, and I'm cautiously optimistic that that rule will be changing some. I think it takes sort of a major case with a lot of public interest to move things that direction, and I suspect that the federal charges pending against Donald Trump and others, there is now a lot more just discussion in the media about changing that rule. One of the things we cited for the court was a poll about people wanting to see live coverage of oral arguments in the Supreme Court. I understand that appellate arguments are different animals from criminal trials, but I think the federal system is far behind the state system in terms of allowing coverage of what goes on in trials.
Okay, well, I want to understand that because Idaho leaves it at the discretion of the judge under Rule 45. Some other states want cameras in and have rules governing that. The entire federal system completely bans cameras, and there are high-profile, important criminal cases of great public interest occurring all the time in the federal system. Would you agree with that?
I agree, Your Honor.
And in all of those proceedings, there are never cameras because it's prohibited by federal rule. And so the policy arguments that the public is not going to have confidence in this case or an understanding of what's happening, I just wonder how that's squared with whatever policy drives the federal courts to just simply disallow cameras and take it out of the judge's hand. Don't you think, in fact, the public can still have that same type of confidence in the proceedings and understanding if they want to come and sit in and watch a trial as they do in any federal case?
Yes, Your Honor. I think certainly people who come and watch trials and see sort of firsthand what is going on, and we certainly had those in the federal, we had people who were just sort of trial watchers who would come and watch every trial, and particularly the ones that had a little bit more notoriety, and certainly those individuals well understood what was going on in the courtroom. Not everyone can do that in every case, and as Mr. Pryor has outlined here, the family members of Mr. Daybell are not able to travel to Boise for a 10-week trial, and I understand there's a motion pending to change that, but for now, in Boise. And I think, obviously, the federal government is not always ahead on policy issues of state courts or state governments on anything. And I think, Your Honor, my understanding is the federal rule is largely driven by the federal judiciary and wanting to ensure there are no cameras in the courtroom. And I think that will be changing as well, Your Honor. I think we're in a day and age where it is just the case that people want to see it with their own eyes. And federal courts are behind the times on that. And so there's a lot more work that needs to be done by people in the federal system, whether it's judges or former U.S. attorneys or criminal defense attorneys, to be able to articulate what goes on in those criminal courts. And there just isn't that, I don't think as good of an understanding. And I do think there have been concerns expressed about outcomes in criminal cases and what it means. And there's a lot less direct information available for people to base that on.
Well, Ms. Olson, I really appreciate your comments on that. It's really interesting to hear your perspective, having been on both sides of state and federal litigation and this issue. Clearly, there are policies in place in our state courts that maybe are different than they are in the federal courts. So thank you for the well-briefed argument and your oral argument today.
And I thank you, Your Honor, for the opportunity to present argument and the opportunity to appear in Fremont County, which is a great courthouse. Thank you.
All right. Thank you, Ms. Olson. Mr. Wood, I will allow a rebuttal argument just from the state at this juncture based on the posture of the case and the comments you made at the beginning. If you have any rebuttal, it's not required, but if there is anything you'd like to add, I'll hear that now.
Just very briefly, and appreciate counsel's comments. Mr. Pryor did bring up a point that I put in the brief but did not bring up, but it is important to note. And Ms. Olson addressed it as well. and the state's position is by broadcasting a trial, it only makes it easier for potential witnesses to make a mistake of seeing something they shouldn't see, of hearing something they shouldn't hear. At the last trial, this issue came up with a few witnesses, and that was just the audio. The state sends out something with every subpoena. We communicate to every single witness, you're not to watch or listen to any of this trial. Sometimes things still happen, and then we have to deal with that in court, and it takes time away from the jury, it takes time away from litigating the case. This is a long trial. I don't know if it's true. I've heard that the preceding trial in this case was the longest criminal case in Idaho state history. I don't know if that's true, but I've heard that. But this will also be a very long trial. This will probably be a longer trial. Broadcasting that length of a trial, we just really run the risk, no matter what we say to witnesses, of people hearing things, seeing things they shouldn't. I know just a couple of things from Ms. Olson's comments. And I'm probably not going to, I probably didn't write this down exactly how she said it, but she mentioned that we live in a day and age of visual coverage of everyday life. I don't know that that's really an argument for broadcasting a trial. I don't know that that's a good thing. And we could probably spend hours talking about all the social implications of the fact that we live in a day and age where everything is televised or put on a computer or a phone, and there's videos of everything everybody does. I don't know that that's really an argument that we should contribute to that. I don't think it's a good thing. I don't think it's a good thing to turn everyday life into a circus. And I think that broadcasting, even if done responsibly and respectfully, will contribute to that. I just finally end on noting, she mentioned the Kyle Rittenhouse case. I brought this up the last time we litigated this. It's interesting because that judge said afterwards, and I quote, "I'm going to think long and hard about a live television trial again next time. I don't know. I've always been a firm believer in it because I think the people should be able to see what's going on. But when I see what's being done, it's really quite frightening." That was Judge Schroeder from the Kyle Rittenhouse case. My understanding is he said that in regards to the context of a jury bus being followed by some reporters. And we're certainly not alleging that any of Ms. Olson's clients are going to do that. But the reality is by broadcasting, we absolutely will create more of this circus type environment, more of this reality TV environment, this true crime obsession. Again, we believe the media should be there. They should report. They have a right to be there, and the public has a right to have the media there. The public has a right to an open trial. We would ask the court to maintain its current order. We believe it was a good decision then, and all the reasons that it made that decision then still apply today. Thank you.
All right, thank you, Mr. Wood. All right, counsel, I've been considering the decision on this issue. I am prepared to make a ruling today. However, I do want to take a quick recess to sort of gather my thoughts and prepare for the ruling on the motions. So we'll take a recess here for about 10 minutes or so, and then I'll come back on the bench with the ruling.
All right.
Thank you. Please be seated. All right, we're back on the record on CR 22-21-1623. The court took under advisement briefly its ruling on the issue of a reconsideration of video and photographic coverage of this case, including the trial. A couple of notes the court will have in making this decision. The court has listened to arguments of the state requesting that we keep the case status quo. And I'll note we did conduct a trial in the Vallow case, which was initially joined with this case, later severed and tried in Boise. During the process of those proceedings, in order to allow some additional access, the court did permit a broadcasting on a limited basis of that trial to two separate locations where the public could view outside of the courtroom. One was a location in Ada County in their courthouse, and then a second location in Rexburg, Idaho. And there were certain reasons for doing that, mainly the fact that venue was changed and the case was taken so far from this location where the home counties are. So that factored into the court's decision. This is now a trial of Mr. Daybell. One of the big concerns I had also for the initial trial was potentially tainting jurors for what I knew would be a second trial coming up if the entire proceedings were broadcast from the Vallow trial, concluding that anyone who had watched that trial or portions of it would likely be unable to serve as a qualified juror in this case. The court has also heard the request from the defense and the rationale for allowing broadcasting of the proceedings, including trial, and the court's considered the briefing and arguments submitted by Ms. Olson for her various media clients who are requesting the ability to conduct broadcasting and photography of the trial during the proceedings. A few things I'll note. First of all, under Idaho Court Administrative Rule 45B, the court has the discretion to make this determination. That rule reads that the presiding judge may, at his or her discretion, limit, restrict, or prohibit audio, video, audio or visual coverage of any proceeding, and those decisions are not subject to appellate review. I am compelled by some of the arguments that a difficulty in moving a trial about 350 miles away from where we currently are certainly restricts access by certain individuals that wish to attend. The argument by Mr. Pryor that the defendants got family members that would like to see the proceedings is a compelling argument. I know from the last case also there are other individuals, family members of victims, family members of defendants, and others very interested in the case or connected to it, which were unable to attend because of the location. I'll note also that the court still has under advisement, and we'll hear argument later this morning about changing venue, but as I sit here to make this decision, we're currently scheduled for trial to occur again in Ada County in this case. In balancing out the requests here, the court is determined, or has made a determination that in order to provide adequate access, the court is going to permit that the trial be broadcast while it occurs with certain restrictions. First, the court is going to be in charge of all equipment and the broadcasting of that. I'm not going to allow that to be conducted by any third parties. The court has the equipment to do so. We did that in the previous trial when it was broadcast to those other locations. It worked well in all the reporting I got back from those that attended and those that ran the system. And with the equipment to do that and the court's own website, which provides an ability to stream it live from the State of Idaho Judiciary website, public is given free and unfettered access to view the proceedings that way. So with that in mind, the court won't allow any still photography, given that the matter will be broadcast on video through the court's own system. And in addressing some of the other concerns as it relates to any microphones placed by any media or third party, of course, those will not be allowed because the court's going to use its own equipment to broadcast the proceedings. And in addition, there were concerns about the exclusionary rule, so witnesses who would be testifying not being allowed to view the proceedings before they testify. I'll note that was already a concern in the first trial with Ms. Vallow, and we had an affidavit that addressed that and required each witness to certify under oath that they had not viewed the proceedings, and did in fact run across a few witnesses who were not able to do that and took those matters up outside the jury. I think that system worked well to make sure that there was not any improper influence on testifying witnesses. So the court will employ that same method of allowing witnesses to testify only after they've been able to certify under oath that they haven't been tainted by viewing previous testimony. There will be some additional technical terms of how the court will allow the broadcasting, and those will be followed up on in a subsequent written order that I'll enter into the case before trial. Going forward with other pretrial hearings, the court will take those up on a case-by-case basis, but this will be the ruling for the trial and how publicity will be handled. So I have balanced out also the concern of certain witnesses who don't wish to be captured on recording forever, and I understand that, and I've had to balance that out. I'd note at the last proceeding, they were also photographed whether they wanted to be or not as they went in and out of the courthouse because it's a public area, and the media was pretty persistent in trying to capture images and pictures of them. So there's really not any way to completely prohibit that, and while that's unfortunate for those that do not enjoy being on camera or all the publicity, that's just part of the stress, I guess, of being involved in a case like this and having to testify. So the court is going to amend its current order as it relates to the case. And as I mentioned, I'll follow up with some additional detail in a written order, but I wanted the parties to be aware of where this would be heading as we get closer to trial. So that will be the court's ruling on the motion at this time. Mr. Wood, does the state have any questions on that ruling?
Not at this time, thank you.
Thank you. Mr. Pryor, any questions?
No, Your Honor.
Okay. And Ms. Olson, any comment or question? All right, thank you. That will conclude the first motion then. The next motion we will bring up, if the parties are ready to proceed, will be the state's motion to amend the indictment. This is a motion that the state filed on November 13th of 2023, and a response and objection was filed by Mr. Pryor on behalf of his client on November 17th, 2023, and the court's prepared now to hear argument on that. Who will be arguing on behalf of the state?
I will be arguing this one, Your Honor.
All right, Ms. Blake, are you ready to proceed with argument?
I am, Your Honor.
All right, you may go ahead.
Thank you. Idaho Criminal Rule 7E and Idaho Code 19-1420 are the governing authorities regarding amending indictments. Both of them make clear Idaho Code essentially reflects very similar language to the Idaho Criminal Rule 7E. It adds some additional language regarding prior to the plea being made by a defendant that an indictment or information may be amended. Since we're post the plea of not guilty, not focusing on that part of the section. But essentially both Idaho Criminal Rule and the Idaho Code allow that prior to the prosecution resting the case, an indictment or information may be amended so long as no additional charges are added and the defendant is not prejudiced by the change. We filed this motion approximately 6 months before what will be the start of the defendant's trial. So our position would be that the defendant is on adequate notice as to the request to modify the indictment. I would also indicate that for the benefit of counsel and the court, I did submit a proposed amended indictment with the changes italicized for the benefit of court and counsel to be able to observe those. That was submitted just by email, waiting to determine whether or not the amendments would be approved prior to submitting a new filing. There were three main amendments that the state is asking to modify. I will indicate they reflect the same modifications that were requested and granted in the co-defendant's trial. The first one is to modify the subsections referenced in counts 1 and counts 3. Those are the counts dealing with conspiracy to commit first-degree murder and grand theft. They are specifically dealing with the code sections referencing the grand theft. It would be a request to change it from 18-24034A to 18-24032A. The state's position on that is it actually is more reflective of the language contained within the current indictment, not specific to the defendant, but there was a charge of grand theft. That charge reflected the language regarding that the theft occurred by deception. When we look at the case law in Idaho, looking first to State v. Ghana, 117 Idaho 83, and that's an Idaho Court of Appeals case from 1989. It specifically outlines the purpose of the information is to allow defendant notice and opportunity to prepare a defense. And in State v. Bolus, 93 Idaho 749, that's a Supreme Court case from 1970. There was an amendment made changing the code section from one that described the differences between first and second degree burglary to the code section that defined the crime of burglary itself. And the court found that there was no issue with making that modification. The defendant wasn't prejudiced. The court found the defendant was always on notice that the underlying charge was burglary. In addition, when we look to State v. Dunn, that's 60 Idaho 568, again, a Supreme Court case from 1939. The court found there was no substantial difference to the charge of, to whether or not the charge of obtaining money by false pretenses was that the defendant received or executed the contract. The court found the defendant was charged essentially with having fabricated the contract, regardless of the method in which that fabrication occurred. And again, they found that there was no substantial change. The defendant was properly on notice. There was no prejudice to the defendant. And then in State v. Severson, 147 Idaho 694, that's again an Idaho Supreme Court case, but from 2009. The court laid out the relevant factors to determining whether the defendant was prejudiced is whether it took the defendant by surprise, impaired defendant's ability to adequately prepare a defense, subjected the defendant to double jeopardy, or required extensive further preparation by the defendant in preparing for trial. In Severson specifically, the court found the amendment merely alleged an alternative way defendant may have committed the crime. None of the defendant's substantial rights were prejudiced. Essentially, in that case, the state added a theory that the victim in that case had died from suffocation. And the court found that that did not modify the charge itself. It didn't add a new charge, and the defendant was properly on notice with no prejudice. In this case, the state would say we're in a similar position. The requested amendment does not add a new charge. It simply modifies the subsection under which defendant is accused of having committed the crime. The defendant's properly on notice. In addition, the indictment contains language reflective of that subsection 2A. If anything, the state increases the burden by having to prove the crime was committed through some use of deceit versus simply that a theft itself occurred, that it was simply knowingly. We add that element of deceit. So if anything, it would increase our burden. In addition to that, the state would indicate the actual charge isn't the grand theft itself, especially with regard to the defendant here today. The actual charge is conspiracy. It's just one of the elements is it incorporates the elements of the grand theft as part of that conspiracy. So we think that that is an appropriate amendment. We think we're doing it in plenty of time to give the defendant advance notice of that modification. In addition to the fact, one could argue the defendant was on notice during the course of the co-defendant's trial when the state made these modifications knowing he was charged under that same indictment. So I think the defendant is on adequate notice. There is no prejudice and there is no additional charge with that change. The next requested change would be for, I reference the correct counts.
On that last point, Ms. Blake, I'm not sure you could deem it notice where in the first case that the amendment occurred right before the state rested at the end of the case, and then knowing that this issue was in the indictment here, it's up to the state to make that amendment and change it. So I guess they could speculate that you were going to do that, but until such time as we're here, I don't think they're really on notice that that's happening until we argue it as we're doing today.
And I can appreciate that point. I guess the fact that it was amended would have at least given some indication that there could be the potential. I would agree the actual notice was not until the filing of the document. There had been some discussions amongst the state and defense counsel that we would be filing a motion to amend the indictment, but I would agree until the actual filing, it isn't considered official notice. But I think they were aware of that occurrence during the co-defendant's trial. Looking at counts 1, 3, and 5, the state is requesting to add the language and or between the co-defendants listed in that or the co-conspirators and or potential co-conspirators. The state's position similarly, we look under that same test, and the state's position is this clearly does not add a new charge, and we would also argue it does not prejudice the defendant. In addition to that argument, in State v. Yang, 167 Idaho 944, it's an Idaho Court of Appeals case from 2020. While it was a touch different because this was a case in which they were asking to modify a jury instruction to be given regarding the co-conspirators in the case versus amending an information or an indictment, the court found that adding the language and or was not a substantial change to the jury instruction. What the court essentially found is it is not incumbent on the state or necessary to prove the number of co-conspirators or the identity of each co-conspirator. It's simply that there was an agreement with at least one other person and one of those parties committed an overt act in furtherance of the conspiracy. So knowing that those aren't officially elements of the case, I think looking at State v. Yang, that provides clarification and the guidance that this would be an appropriate modification. In addition to that, we are asking for this well in advance of trial to put the defendant on notice that we would be asking for that modification. I don't think that changes anything with regard to the elements of the crime or the burden required. And I think that has clearly been litigated in the courts here. The last one that the state had noted in the motion itself to amend the indictment was a change to count 5 and specifically overt act number 10. The state is asking to change the month to months with adding the S. Essentially, it was a typographical error, requesting that it be changed to the months before. And looking again at some of the cases we've cited to before, Ghana, the defendant had argued that he was not on proper notice because the state added a charge of persistent violator 3 weeks before trial. The court found that was sufficient notice in amending that 3 weeks before trial to add that. And then again, looking at the test outlined in Severson, the state's position is this does not add a new charge and it does not create any prejudice to the defendant. It is not a double jeopardy issue. It's not going to create any kind of extensive preparation by the defense or further preparation by the defense. In addition, the state would argue similarly that this modification was made during the co-defendant's trial. The defendant has been in possession of the discovery in relation to this case. The defendant has had the benefit of watching the co-defendant's trial and or observing and listening to it, where it is clear that this was what was presented during the trial, was that it included the months. In the amended indictment sent to the court and counsel, there were a few other italicized proposed changes. Those were not specifically addressed in the motion. They're simply typographical errors or errors where certain language was left out. I could go through those, but essentially the state's position would be similar to what we just argued with the months. They're not adding new charges. There's no prejudice to the defendant. We're bringing them in advance of trial, requesting permission. The state does recognize that it is in the discretion of the court once a plea has been entered by the defendant, whether or not a state is allowed to amend an indictment or information. However, both the rule and code make clear that before the prosecution has rests, that it is appropriate to bring the motion. So with that, the state would request that the court grant this motion to amend the indictment reflective of the changes sent to the court and counsel.
All right, one question, Ms. Blake, on some of the proposed amendments here. If you have it in front of you, the proposed amended indictment,
Yes.
page 6, there's common scheme or plan in Fremont is how it reads now, and it says Fremont and Madison counties.
Yes.
Do you want to address whether or not that would be permitted pursuant to the rule, or does that require any further findings by the grand jury?
I don't believe it requires any further findings by the grand jury for the reason that it was simply a typographical error and left out. When you read the count and the contents of it, it includes in the county of Fremont, state of Idaho, and elsewhere, including Madison County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Fremont counties. So, and Madison was simply left out of there. In the same body of that count itself, it includes Madison County already. So it was simply to correct the confusion that may be from Fremont and then having counties, and Madison was simply left out. But the rest of the indictment and the information presented included acts in both Fremont and Madison County, and that's what has always been purported and alleged by the state. So I would argue similarly, it doesn't modify anything. It doesn't it doesn't modify it as far as a new charge, and it doesn't prejudice the defendant. I don't think it creates any kind of a venue or jurisdiction issue either, especially given what's in the body of the rest of the indictment. It would simply be to alleviate any confusion that may be seen there by having simply Fremont and then the plurality.
All right, thanks for the response on that. All right, the state submitted its argument in support of the motion. Mr. Pryor, if you'd like to present your argument in opposition, you may.
Judge, there's no doubt that the prosecuting attorney has a right to amend the indictment right up before the close of their case. And again, I was aware of some of these. I'm not going to argue the month or months. I think that's, given what they've represented, that's appropriate. In addition, in terms of the overt acts that they talk about, including the language of Madison County, I guess.
Could you just pull the mic a little closer there? Sorry, we're not picking up the recording.
That was not good.
Alternative, you can argue standing or from council table either way.
Judge, in addition, I guess I could make an argument. Is that acceptable? The level of noise, sound?
It's still a little quiet, the clerk says.
That any better?
Yes.
I'll try to lean forward and talk that. Judge, I've never been accused of not having a loud voice, so this is new for me. And the court's smiling. Court's aware of that as well. Thank you. Judge, in regards to the Madison County, quite frankly, the state is right, and at least in this perspective, they're right. They alleged in the actual body of the language that Madison County was above that, and about 2 lines above the change they're alleging, they actually mentioned Madison County. So for me to suggest that they can't do that would, I think, be improper. So I'll agree to them allowing that. There is an argument, I guess, in terms of bringing it back to the grand jury to make a representation about the venue, but I'm not going to engage in that today. However, what I am, Judge, going to engage in is the language on counts 1, 3, and 5. This is my concern. I understand the previous case Ms. Blake represented talked about that the and or was not a dramatic change in terms of what's represented. But the concern I have with this, Judge, is if you look at the actual indictment and look at the language, they're alleging that Lori Vallow and or Chad Daybell and or Alex Cox and or the other conspirators that were involved in this case. Now, to date, and there we've dealt with this before, we have no idea who the names of these other conspirators are, or at least the state hasn't disclosed the other conspirators that were involved in this case. But the concern is that it shifts the burden, and it changes the burden that the state's going to have to prove. And how it does that is this, is that a jury who are not legally educated citizens are going to look at the indictment and say, well, under this particular allegation, we don't actually even need to prove Mr. Daybell did anything wrong. What we have to prove is that, well, it could have been Lori Vallow or Alex Cox or the other conspirators. Don't even need to prove Chad Daybell to find him guilty. All we have to do is that the others were involved in this. That's all that, and that kind of logical thinking can go towards what the jury would be thinking about this. And unfortunately, if that's what they want to do, then they need to take this back to the grand jury and have them approve this language and say, we're going to indict Mr. Daybell because and/or can be defined as meaning whether he could have done it, yeah, and he could have been there, or it could have been the others. But if it's just the others and not Mr. Daybell, we're still going to find him guilty because the amendments that the state is alleging in terms of count 1, count 3, and count 5, that sort of thinking can take place, and that is my concern, and it's confusing. And I know Mr. Archibald touched on this at the time, and the court allowed these changes to go forward. But my concern again is this, Judge, is that the plain reading of that language by including and/or between the unnamed co-conspirators that we don't know I don't know who the names are, Alex Cox, Lori Vallow, and Chad Daybell, the state put and/or on all of the names, change that, and that in essence changes how the plain reading of that particular phrase can be interpreted. That is my concern. And it's enough of a concern, Judge, that technically you could look at this and say, Mr. Daybell could be found guilty of 1, 3, and 5 without having done anything, given that the others, or the others could have been involved and they could impute that onto Mr. Daybell. That's my concern. Lastly, I understand that they're alleging grand theft under 2403. My concern is that they alleged it in front of the grand jury under one particular section of 2403. They are now changing that to a different section under 2403. The case law is not clear at this point as to whether or not changing the underlying charge or any of the subsections, it doesn't address that. It does say that if you change the underlying charge, that could be problematic. It doesn't address whether changing the subsection and the level of proof that they're going to do, and I would concede to the state that it's not 6 months, Ms. Blake, it's 4 months before we start the trial, less than 4 months at this point. But I would concede, Judge, that if the court finds that just changing the subsection is not enough of a change, obviously I would accept the court's decision, but it is a different subsection under the grand theft charge, and it does require a different burden of proof. And the state saying that it's made it more difficult on them, I don't agree with that. What they've done is they've changed the subsection on what they're trying to get Mr. Daybell convicted of under the crime of grand theft to a different subsection. That is a change. No matter how you put it, whether or not it's permissible, I'll leave that to the court's decision.
All right, thank you for the argument, Mr. Pryor. Ms. Blake, do you have any rebuttal argument?
Just briefly, Your Honor, as the state indicated with regard to the grand theft, the actual charge is conspiracy. And so I would indicate that again, as well as the cases previously cited, which do allow for which have in the past allowed for amendments that change the theory of how a case or under which elements or theory presented under subsections the crime was committed doing. In addition to that, I think State v. Yang makes very clear that regarding a conspiracy, the state is not required to prove the number of co-conspirators, and they're not required to prove the identity of the co-conspirators. Again, a conspiracy, the state's burden would be to prove that there was a plan engaged in, a common scheme or plan, and that at least one of the actors engaged in that plan committed an overt act. There is no requirement that every person engaged in a conspiracy commit an overt act. So I think to indicate that somehow others' actions may be imputed to Mr. Daybell, that probably is not a wrong assessment by the defense, but that's the nature of a conspiracy, is any one of the co-conspirators committing a bad act is one of the elements of a conspiracy. So I don't think in any way modifying the and or adds any additional burden on the defendant, and in no way is it burden shifting. The state's requirements under conspiracy remain the same.
All right, thank you, Ms. Blake. All right, I'm prepared to make a ruling at this time on the motion. This is the state's motion to amend the indictment in this case. The court will note under Idaho Code 19-1420 that there reads amendment of indictment may be amended by the prosecuting attorney without leave of the court before a plea. We're after a plea here, so at any time thereafter in the discretion of the court where it can be done without prejudice to the substantial rights of the defendant. So that's the standard the court looks at contained in that statute. There are some clerical amendments being requested, and there are some substantive amendments being requested in the state's new proposed indictment. The court's looked at the case law on this issue. There's a case, State versus Jeske, 164 Idaho 862, and it's a 2019 case that says the decision to permit an amendment is a matter within the discretion of the trial court. And then that case also cites to a case, State versus Severson, 147 Idaho 694. The court may allow an amendment of an information, and in this case, an indictment would apply at any time before the prosecution rests, so long as doing so does not prejudice the defendant's substantial rights or charge the defendant with a different offense, and then citing to Criminal Rule 7 and Section 19-1420 that I just mentioned. So there's discretion here for the court to consider it, starting with the clerical corrections requested, and included among those the addition of the word Madison County on page 6. The court finds that the state's motion is permitted pursuant to Idaho Code 19-1420 on what I'll consider the proposed amendments that are clerical in nature. So the motion's granted on that. Going to the more substantive requests of the state, primarily on counts 1, 3, and 5, where there's a request to amend the stated statute under which grand theft by deception is contained in the indictment. Initially, it was listed as 2C, I believe, which is, or was it D? What was the initial, I know it's being changed to 2A if you have it amended, but what was the subsite that was in the initial indictment? I could pull it up.
We have it as 4A, Your Honor, that it was initially under 4A.
4A. Thank you for the direction there. The theft statute is kind of a large statute, but the request is that under 4A, which would be by possession of stolen property, it's to be amended to 2A, which was theft by deception. The court will note I did previously look at a similar request to amend in the prior case, and that's relevant here. And I'm talking about the Lori Vallow case, the 1624 case, because the indictment is the same between the cases and the parties here. So I noted then when I considered that at trial and allowed the amendment that the language of the indictment has read by deception, and it would comport with the offense under the 2403A under 2A to be theft by deception. I don't find that that constitutes a new charge or a different charge. Either grand jurors or trial jurors are not pulling out the code to read the code sites to see if that's what the offenses. They simply follow the instructions of the court that are provided that list out the elements of a crime. And the question here is whether or not Mr. Daybell was adequately put on notice of the theory of the state's offense as it relates to the theft part of this conspiracy charge. And because it was listed as theft by deception all along in the caption, and because also the language within those counts 1, 3, and 5 described theft by deception, the court does find that allowing the amendment to 2A more accurately describes the statute upon which the defendant's been charged and does not constitute a new charge, nor does that result in a prejudice to the substantial rights. I'll allow the amendment then on those provisions, also noting that at this point, we are still in advance of trial, not real far in advance of trial, but enough in advance of trial that the defendant is adequately advised of what the charges are. I don't find that any of the proposed amendments either would require resubmission to the grand jury for a determination that probable cause was found on these offenses, and that this can be amended by motion, which the state has done today. Finally, I would also agree with the state's position here that on the and/or provisions, that the underlying offense as actually charged here is the conspiracy offense. And under conspiracy law, the state's burden here is to show a common scheme or plan as alleged and an overt act. And the case law, including the Yang case cited by Ms. Blake, permits the state to have alternatively listed co-conspirators following conspiracy law. And because it's charged as conspiracy on those counts, I also find that does not result in any new charge or a prejudice to the substantial rights of the defendant. So I find the motion to be timely at this point. The court will grant the motion to amend the indictment, and the proposed amended indictment as received by the court will be allowed to be filed in the case, and that will be the indictment that will instruct the jurors at trial. That'll be the court's ruling on the motion then. Ms. Blake, do you have any questions on that?
No, Your Honor.
Mr. Pryor, any
No,
questions?
Your Honor, thank you.
All right, thanks, counsel. The next motion before the court is the state's renewed motion to reconsider the change of venue. This motion was filed by the state on November 15th, 2023. The defendant filed their response and objection to the motion on November 17th, and this relates to the court's pending decision or current decision that the trial will be conducted in Ada County. Who's going to be arguing that motion today?
I will be, Your Honor.
All right, Ms. Blake, are you ready to proceed with argument on that?
Yes, Your Honor.
All right. Why don't we do this? Let's have a quick about 5-minute break in case there are anyone here that wishes to either use the restroom or leave before we proceed with the rest of the motions. So we'll take a quick recess and then come back on and start with the change of venue motion.
All rise.
Restroom. We are back on the record, KCR 22-21-1623, State of Idaho versus Chad Guy Daybell. We are scheduled next to hear a motion on the state's renewed motion to reconsider change of venue. Motion filed November 15th with an objection filed November 17th. I can't recall who was arguing this, Ms. Blake.
Yes, Your Honor.
Ms. Blake, if you'd like to present argument in support of the motion, you may.
Thank you, Your Honor. And the first thing the state wanted to address was, I think, in the defense's response, there had been an indication that motions to reconsider are inappropriate or not allowed. So I just wanted to go ahead and address that first. They are allowed under State v. Montague, 114 Idaho 319. That's an Idaho Court of Appeals case from 1988. The court makes clear that it is in the discretion of the court whether or not motions or requests for reconsideration are considered. Essentially, the court pointed out that because such a request is not specifically mentioned in the rules of criminal procedure, a trial court is not without power to act upon it, but essentially it would be within the trial court's discretion. And they also looked at the federal rules of criminal procedure, which similarly do not contain any such motion, a rule regarding a motion or request for reconsideration, and specifically found the federal courts have held that a trial court is free to entertain such a motion when made. And then essentially the Idaho court joined in that finding. In addition, State v. Wolf, it's 2013 APP Lexus 86, and that's an Idaho Court of Appeals case from 2013. In that case, there was a motion to reconsider a Rule 35, and similarly, the court looked to State v. Montague for guidance and found that a motion to reconsider can be allowed, and then they went through an analysis as to whether or not it was proper with the Rule 35. Ultimately, they found that it was proper, that it could be considered by a court, a motion to reconsider a Rule 35. In that case, it came down to a timing issue. I think a couple years had actually passed on some appellate issues that court was looking at, but the actual motion to reconsider was found to be appropriate. So I do think it's clearly established in the Idaho rules that a court is allowed and can consider a motion to reconsider. The courts go on to talk about, I believe it was State v. Montague, it may have been Wolf, so I apologize, I should have had notes about that. But essentially, they talked about that there were some additional facts and considerations that were brought forward for the court to consider. I think it was in Montague, and it was regarding some evidence that was not presented at a motion to suppress by the state, but that the state had in its possession. So they had asked for a motion to reconsider and present that evidence. The appellate court found absolutely the court could consider that. They did kind of admonish and say maybe the state should have brought that the first go round, but where it was new information not previously presented to the court, they found it was absolutely appropriate for that court to reconsider. The reason I bring that up is I think we find ourselves in a similar situation. However, this information was not within the state's possession at the time the original motion for change of venue was brought forward. But we are in a new situation with the passage of time, as well as new media coverage and heightened media coverage in Ada County. So
Before we go into the merits of the motion, then I'll make a comment on that, on the reconsideration, because I think there's some inconsistency in the Idaho case law, because I'm aware of other cases. I know of one in particular that, and I don't have the cite off the top of my head, but I've used it on many occasions with attorneys in criminal cases that says, unlike the civil rules and the Idaho criminal rules, there is no motion to reconsider. That being said, I do think that within the court's discretion, at times, there are certain types of motions that merit reconsideration, motions that develop additional evidence, motions in limine, et cetera. This particular motion, as it relates to a request to reconsider the change of venue, I would find appropriate. So despite potentially conflicting case law on that, I think it's procedurally proper to bring the motion. And so I'm just saying, don't be concerned about a ruling based on you can't reconsider this, because I think in this case it can and should be reconsidered. So with that in mind, if you'd like to go into the merits of the argument, you can.
thank you, Your Honor. And I appreciate that clarification from the court that there is case law disputing that. I had found the cases that specifically allowed for it. So looking at the merits of the motion itself, where the state believes that we are at is there are a couple different rules that govern requesting for change of venue. The state does not believe that we are in a position of actually requesting a change of venue. That was done by the defendant, and Idaho Code 1801 specifically says the defendant can request a change of venue if they feel that there would be bias or prejudice or an issue with holding it in the actual venue where the crime is alleged to have occurred. In this case, there's no question that Fremont County is the originating venue and the appropriate venue. The defense brought a motion back in, it was ruled on in October of 2021. It was filed before that. So it was ruled on quite some time ago. I know the state had done a motion, essentially kind of a hybrid motion to reconsider and also to consider bringing in a jury. So reconsidering some of the findings made with that order. However, now there has been a significant longer passage of time, in addition to the fact, of course, the biggest change was the defendant essentially demanded a severance, requested the severance, and was granted that severance. After that severance was granted, the co-defendant, Lori Vallow, opted to proceed with her trial in Ada County. And the reason I say opted to proceed is, as the court probably recalls, it was actually the defendant that brought the original motion to change venue and was granted the change of venue to Ada County. However, at that time, the cases were still joined for trial, and when Ms. Vallow was found competent and her case also started moving forward, the indication from her and her counsel were they were fine with the change of venue. They were in favor of it, essentially, and they never requested anything different. So we proceeded with her trial. That started the end of March of this year and proceeded into mid-May. And as the defense points out, some of the timing and referenced in some of these motions is off, given the hearing date versus when they were filed and when the initial drafting was started as well. But we are now less than a year from when that all occurred. During that trial, there was daily coverage. I know that's been covered in part in the motion to allow cameras back in the courtroom that was argued today by the parties. A lot of that was already referenced. There were daily reports coming out. There were interviews being conducted on the courthouse steps daily throughout the trial. Those interviews included comments on evidence that was presented, opinions on the credibility of witnesses, opinions on the culpability of the defendant and the co-defendant. I know there were some references made regarding Chad Daybell during that time as well. So with that, we just think based on the original argument made by the defendant that he thought the coverage was too pervasive here in the 7th Judicial District and specifically Fremont County, we now find ourselves in essentially that same position, but in reverse. The coverage in Ada County has been very pervasive. The state does recognize that when we look at the numbers, the coverage in the 7th Judicial District as a whole and Ada County area as a whole is very similar. Ada County numbers tend to come in a little bit higher, but we recognize the coverage is still broad in both areas. However, we would indicate that at the original change of venue, there were no specific findings made with regard to Fremont County. Fremont County was clustered into the 7th Judicial District, and in part that dealt with a witness for the defense that ultimately any testimony regarding Fremont County ended up being excluded because enough people weren't polled to make accurate or sufficient findings regarding the pervasiveness in Fremont County. Some of the other things looked to were the vigils and things that had gone on in relation to this case here in Fremont County. At the time the order had come out, it would have been approximately 14 months since the most intensive media coverage, which really circled around the finding of the children's remains. Since the finding of their remains, I believe at the time the motion was filed, it had been about 28 months. And so we have a significantly larger passage of time from when that media coverage was so intensive and from when the vigils and things were being held here in Fremont County. But we are now only about 6 months away from when that was going on in Ada County. There were crowds gathered at the Ada County courthouse steps to hear the reading of the verdict. In addition to that, in Ada County, we had approximately 1,800 jurors that were summoned in. We had approximately 700 that were subjected to voir dire, and which included some of the information regarding the underlying facts of the co-defendant's case, which are also similar to the underlying facts of the defendant's case here today. So we have a significant pool of jurors that have now been exposed to that. In addition to that, those jurors are not told not to talk about the proceedings, whereas in Fremont County, a grand jury was seated quickly and the grand jury proceedings are secret. So any jurors that sat here in Fremont County on this issue have been still ordered not to speak about that, whereas the jurors in Ada County are now free to discuss that. In addition, when we talk about individuals.
Like there's one thing I do want to bring up here that occurred in Fremont County that I think was probably the pinnacle of media exposure of the whole case. Lori Vallow sentenced here July 31st of this year in this courtroom, and I haven't looked at any objective data, but I would guess that was probably the single most covered event of either of these cases, and that occurred here in Fremont County pretty recently. So,
and I think what we had found on that is Ada County was covering that just as heavily as this area would have been. So I do recognize that occurred here in Fremont County, but it was of daily coverage.
But the event here, I guess you could say, was maybe more than that, because I know people were literally camped out here the day before. They were all around the courthouse for 24 hours before that, and the courtroom was packed to capacity. And I see that, if I'm following the logic of your argument, of being pretty problematic as it relates to potential jurors here in Fremont County.
And I can understand the court's concern with that. I guess the state's position would be, when we're looking at the media coverage and what has been broadcast, the quality and the quantity, what we found is that it was very similar in Ada County. So even though the sentencing occurred here, the media coverage was just as pervasive in Ada County regarding that event occurring here. I do recognize we had a packed courthouse. I recognize there were a few individuals that camped out on the courthouse lawn. I would also indicate during the trial in Ada County, the courtroom most days was packed to capacity. There were some days that it wasn't, but we had an overflow room to allow for individuals to watch the trial. And I do think that that was attended at times. Through certain portions of the trial, I think that was pretty packed as well. I didn't go down to look, but I know the courtroom was at capacity for some of the events with that trial, including, I think at a minimum, the closing statements and also the verdict being read there in Ada County. But I do recognize the court's concern with that. I guess the state's position would be that the coverage did not continue, even if it was pervasive, even if that was a highly covered event, it did not continue for months after that. Ada County's interest seems to have been piqued even more so by the trial being held there. We had individuals in public roles in Ada County that gave interviews. The only reason I bring that up is I think oftentimes if it's someone you know, someone that may be a public figure in the area you're from, you may be more likely to hone in on that. Those interviews were conducted there at the courthouse in Ada County. So displaying the courthouse, I think there was note of some vigils being held here at the Fremont County courthouse years ago. And so again, just looking at that raised some additional concerns and some additional facts that the state thought should be considered at this point in time. And I think, again, just really focusing on the defendant's initial arguments in his motion to change venue. Essentially, it was a motion to change it out of the 7th Judicial District because there was really nothing presented specific to Fremont County. So the state's position is Fremont County does have a smaller population than Ada County, and we absolutely recognize that. But we do believe, given that we were able to seat a grand jury, given the passage of time from some of the main events occurring here, and I will give the court, with the exception of the sentencing, the other main events that have occurred here, there's been a longer passage of time from when we had this massive trial. The court had also focused on the media coverage regarding the co-defendant in the initial order granting the change of venue. That coverage only intensified during the trial there in Ada County. Again, the state does recognize that coverage was here in the 7th Judicial District as well. But again, nothing specific with Fremont County has been presented or located regarding that. We do believe that a fair and impartial jury could be chosen here in Fremont County. I know this matter has been brought up in a motion to reconsider, but of course also factoring in the cost to the county.
Judge, I'm going to object at this point. They didn't bring up the cost specifically in their motion, and quite frankly, I've been quite patient. The fact of the matter is their argument was based literally to the media coverage, and if they're going to be allowed to expand on this, then I want a continuance, and I'm going to go back to every little item, and we'll have to go through this again. So at this point, I'm objecting to this financial argument because they did not make any mention of that.
I thought there was a mention.
There was a brief mention, but I'll just keep it brief. That is all I was going to say really regarding that. Is what was contained in the motion is obviously some of the factors the court can factor in and consider when determining whether or not a change of venue is appropriate are the costs and things. I think the court addressed that in the prior motion. The state, Fremont and Madison County are cognizant of that issue as well. And so we just bring that to the court's attention also. As an alternative in our motion, we had indicated, again, looking at the population of Fremont County and considering that that may be a concern for the court and a factor because of the pervasive coverage in Ada County, because the defendant opted to request a severance and the co-defendant opted to proceed in Ada County. I think we are now in a different situation. So we would ask the court to reconsider whether or not Ada County is the appropriate change, the appropriate venue, if the change of venue is still determined to be appropriate, given that.
Ms. Blake, do you have I don't know for sure the number. Do you know currently what is the population of Fremont County? I mean,
I should know.
I think it's around 14,000 people.
That sounds about accurate. I don't know when the last census was done. I should have that information, but that sounds accurate, which I do think is a large enough number to pull in 1,800 potential jurors if we were to follow what we did in Ada County.
All right, and I would need to confirm. I had heard at one point from a jury commissioner here that I thought there were around 2,000 qualified jurors total out of Fremont County. And at our last trial, we pulled 1,800 for starters, and that was not a capital case. And we may have to look at additional issues that come up with juror disqualifications with a capital case. Just looking at the numbers there, though, but if we're looking at around that 2,000 qualified jurors, and I just note that something I did look into and have to consider, despite the media coverage in Ada County, I mean, it's a whole nother world in terms of population there. They have approximately between 275 and 300,000 qualified jurors out of Ada County. So it's, 100 times, I guess, the amount of potential jury pool there. And I'm just making some commentary here, and I'm not deciding the motion at this point, just making some commentary, but I'm fully cognizant of the burden and cost and expense and concerned about that as well. So I do appreciate you raising that. The court has to take those issues seriously when determining